Welcome to Legally Speaking. My name's Amy Oliver.
And I'm Josh Berkley.
And we're here at Berkley Oliver. So today we're going to talk a little bit about basic estate planning. And what is basic estate planning?
Well, we usually say basic estate planning has three main components. That's a last will and testament, durable general power of attorney, and advanced healthcare directives, which is usually in Kentucky a healthcare surrogate designation and a living will. If you're in another state, they may call that a healthcare power of attorney, but Kentucky statute calls it a healthcare surrogate designation, so we're going to stick with that.
Yeah. And for everybody out here, if you're in a different state, laws might be different. And again, this is for informational purposes only. It's not legal advice.
Absolutely.
So tell me, what do you need to put in a will?
Well, a lot of people don't think they need a will because they don't have a lot of assets. But even folks that don't have a tremendous amount of assets still have very good reasons for needing a last will and testament.
One of the things that we see all the time are blended families. So you have maybe a second marriage, you have kids from a former spouse, you have current kids, or your spouse has kids. And Kentucky law will give you an estate plan if you don't have one.
That's right.
And it may not be what you want. And so what you need to do is be able to set who gets what when you're no longer here.
Yeah. All too often, people will think that if they pass away, their spouse gets everything.
That's not true.
That's not right. Under Kentucky law, if you don't, depending on how you have your estate plan set up, if you don't have an estate plan set up, Kentucky law is going to default to your spouse will get about half of what you've got, and the other half will go to the children. And Kentucky law does not care if those are minor children. Those could all be set up under guardianship and blocked accounts, and it makes things a lot more complicated than it needs to be.
And we've seen it happen where, let's say a parent dies suddenly at a young age, they don't have an estate plan, and their kid ends up owning the house with their spouse. And that child has to have a blocked account, the court's going to be involved, and they essentially have to get court approval if they want to sell the house and move somewhere else.
Yeah, it creates quite a problem. And the other issue often is with people looking at getting a will done is they think they don't need it because, as we said, they don't have a lot of assets. But as many people as are trying to plan for the transitioning when they pass away of a lot of assets or a great amount of land or property, we have a lot of people that what they're really concerned about, they're younger couples with small children at home. And the will is also the venue that you're going to want to use to appoint guardians over your minor children.
Yeah, you definitely have, as a parent, and I'm not, but Josh is, he definitely has an idea of who he wants to take care of his kid if something happens to him and his wife. And I'm the same way with my pets. So in my estate plan, I have somebody that's going to take care of my pets if something happens to me and my husband. A lot of the time, people come in here and they say, hey, I need a trust. Why do I need a trust?
The reason people usually think they need a trust is the reasons they give us usually is, well, it's the best. And my answer to that is usually, well, the best for what? What is it you're trying to accomplish?
But wait, it'll avoid probate because probate's an ugly process, right?
Not usually.
No, it's really not that ugly. There are two ways to go about probate in Kentucky. One is what we call a dispense with. It just dispenses with the administration. It means that you have a shortened probate period. A traditional probate has to be open for 6 months, and that's really not that long.
People usually think it's going to be very expensive, and it usually is not. Typically, when things get really expensive, is actually when family gets to fighting. That's where the added expense comes in. Otherwise, it typically is not. The legal proceedings and what's required under Kentucky law do not make it a very expensive process.
No, it's not, and it's relatively simple. I always like to use the Who Framed Roger Rabbit when Eddie's. He said, all my money's locked up in probate. It's not that way here.
You just dated yourself, Amy.
I know. I'm a millennial. I'm an elder millennial. Yeah, I dated myself.
So back to the trust. Meanwhile, back at the ranch.
Back at the ranch.
The other issue with trying to say, well, I'm going to skip probate. We're going to get everything loaded up into a revocable or a revocable, people say it both ways, living trust, and I won't have to worry about probate. Having a revocable living trust does add a layer of complexity to your affairs.
Yeah.
That every bank account you're going to now have to sign as trustee. If you want to transfer real property, you're going to have to sign as trustee. You can't just sign in your own individual capacity. And that turns out to a lot of times be a lot of headache for people and kind of things you've got to think of and be cognizant of every time you write a check. There's no problem with that, and certainly we're able to help people kind of navigate that issue. But it's an unnecessary complication if you don't actually need that.
Right. Right.
Like if you've got a good reason, and we've said usually avoiding probate's not a good reason.
No. In Kentucky, it's not. Maybe if you lived in another state where probate was a big headache, we hear of California or Florida, but not here.
Yeah, some other states do have different structures for their probate and do take different fees and things out of it. We're not really qualified to talk about that because
Yeah.
lawyers are, if you did not know, lawyers are also licensed state to state. So every state has different laws, okay? So if you are talking to an attorney, you need to make sure you're talking to one and you're not just Google searching something. Talk to a lawyer qualified in your particular state because you need to know what that state statutes are. If you are in Kentucky, it doesn't make any difference what Indiana's laws are, right? Or Ohio's laws are. It's Kentucky law that's going to affect your probate, your estate, or any other legal matter that you've got pending.
So talking about other states, sometimes we see people who may have a vacation home in another state. That's another reason that we use revocable living trust.
That's a real good time for a living trust. At that point, you will avoid an ancillary probate. Now, what is an ancillary probate? Ancillary probate is where you pass away in Kentucky, but you've got a condo in Florida. Well, now you've got to do the Kentucky probate, but then you've got to turn around and do
a Florida probate.
An ancillary probate in Florida. Now, what did I just say a minute ago? I said we're licensed state to state, meaning we can't do a Florida probate. We can't do an ancillary probate. So now we have to work with you to hire a Florida attorney to go and do the ancillary probate. Now we're starting to get into some significant headache and some significant fees that may make it worth considering putting that Florida property into a trust that transfers on death just by the trustee signing it over.
Yeah. Even if you do a trust, you're still going to have what we call our basic estate plan, which is the last will and testament, healthcare power of attorney, healthcare surrogate designation, durable power of attorney. One thing, your will is going to kind of pour everything over into your trust.
Right.
But I also want to talk a little bit more about the power of attorney. So one thing that I deal a lot with, and we may talk a little bit more later, is guardian and conservatorship. And so it's technically in the statute a disability trial, disability designation.
Right.
It takes away rights and gives it to someone else. It says, I can no longer control my finances.
That's right.
I can't make my healthcare decisions. I'm going to give that to someone else. By having a power of attorney, a durable general power of attorney, you can avoid that possibility later on down the line.
And a lot of people have confusion about that. They think that if they do a power of attorney, they're giving something up. And I always try to liken it. I say, you're not giving anything up. It's like dual steering wheels. Someone else can sign for you, but you don't lose your ability to sign documents for yourself. It just allows someone else to help you with that. Typically a spouse or a child can be anybody that you appoint, but that's most often what we see is with a spouse or a child.
And it's really good too if maybe you do live in another state half of the year, or you have a vacation home, you're gone for an extended period of time. Well, if your home has a water main break or a water leak or something like that, you might need somebody else that can come in here and pay to get it fixed. It's just good to have a backup, somebody who can take care of things if you're not able.
Yeah. Yeah, and the thing is, too, a power of attorney, I mean, that's a document we can easily do in the office, but if you don't have a power of attorney and you've got to have somebody sign off for you, and an example of that is we had someone trying to sign a spouse into an assisted living facility, assumed as the spouse they would be able to do that, wouldn't be any problem. Makes sense. I understand exactly why they thought that, but it wasn't true. The assisted living facility said, no, you've got to have a power of attorney or a guardian over this individual to be able to sign them in. Well, they didn't have a power of attorney, and the person that was, it was like the husband being signed in, and the wife was the one trying to do the signing in. The husband no longer had mental capacity, was no longer mentally competent to sign documents for himself, which means they can't sign a power of attorney then.
Yep.
So they have to have that. But then they had to go see Amy and have a guardianship trial.
Yep. And it's not every long-term facility or assisted living facility will require that. And another instance we had somebody who had a power of attorney, but in Kentucky there are 4 different things that the statute says that a regular power of attorney, if they don't spell these 4 things out, that the power of attorney can't do. And one of those is create a trust. And so when we talk a little bit later about Medicaid planning, there's something called a qualified income trust. Medicaid requires you to have certain asset limits and certain income limits. So if your income, if you have like retirement, pension, Social Security, it might put you over that income limit. What do? You create this tiny little trust called a qualified income trust.
It's a real easy fix if you have the power of
If
attorney.
you have the power.
If you don't,
And they didn't have the power in the power of attorney. So we had to go to district court for a disability trial to have the judge give the power of attorney, the person who was the power of attorney, the ability to manage that person's finances, to create that trust.
so I think that's the second part is making sure that your basic estate plans, that you're working with someone experienced in estate planning and elder law, because almost any attorney will write you a power of attorney.
Yeah.
Okay, I mean, obviously you can get online and gin one up with ChatGPT in 2 seconds. The magic in it is not in just having a piece of paper. The magic in it is in making sure that it has actually the right provisions, and where it needs to add powers not granted by default under Kentucky law for an agent under a power of attorney, you need to make sure that whoever you're working with knows to put that in there if you're trying to plan for events like Medicaid planning or long-term care or things of that nature.
Yeah. Otherwise, you have paperwork that doesn't do what you want it to do.
And that's the problem is we have people all the time show up and they say, "Oh, we're all good. I've got the power of attorney," and they come in here and it's like, it's missing these 3 things. And they go, "What are you talking about?" It says I can do everything they can do. And I always tell them, unfortunately in Kentucky, everything doesn't mean everything. Everything has exceptions.
The statutes do that a lot. They do. The legislature has carved out those exceptions, and if they're not in there, there's no way to get around it. And
That's right.
banks will be the first ones to tell you, you can't do this here. And that's how we've seen some of these documents come into our office.
So let's talk about advanced directives a little bit.
Yeah.
The healthcare surrogate designation, again, in other states sometimes called a healthcare power of attorney, and a living will. So the healthcare surrogate designation, we just talked about the general durable power of attorney, and that's really for like your business and financial matters. Who can do your banking, who can do things with your insurance and brokerage accounts and real property and all those things. A healthcare surrogate designation is when you are unable to speak for yourself. When something is going on with you from a medical perspective, who has the right to tell the doctor, do this, don't do that, they want this, they don't want that? That's going to be who you appoint under that healthcare surrogate designation.
And here's a prime example. In fact, I saw a TikTok on this. It was a doctor, and he was parodying that he was going in to take out an appendix, and he found cancer. Exactly. Oh, but wait, what did we have the patient consent to? And if they didn't have the patient consent to taking out some form of cancerous mass or anything like that, they can't do it. They have to sew you back up.
Wake you up and then do another surgery.
Exactly. And nobody wants that. And so your healthcare surrogate, they can go and step out and say, "Hey, we found this. Do you authorize us to remove it?" And most of the time your healthcare surrogate's like, "Yes, of course."
Absolutely.
And that's a very simple way to say it. But, if you get hit by a bus and you're unconscious, somebody's got to consent to your medical treatment. That's a prime example of healthcare surrogate. Most of the time, most people will choose a spouse, a parent.
Or adult child. And the thing that often goes with this, and sometimes there are some online forms that kind of roll these all into one. I like to see them separated, where you have the healthcare surrogate designation and the living will separate. All the time people get confused too between a living will and a last will and testament. Last will and testament we talked about earlier. That actually kind of divides out your stuff, says who's going to be your executor and take care of your probate, and who would get your children if you pass. That's all about transferring things. The living will is all about it, making decisions about your health care at the end of your life that you want to make now rather than waiting for later. Okay? 99 out of 100 times people will say the same thing. I don't want to be, if doctors agree that I'm not going to be able to recover and have any quality of life, I don't want to be kept alive through artificial nutrition, hydration, or ventilation, but I do want pain management to keep me as comfortable as possible until the end. That document is customizable. You can have none of that, all of it, whichever portions you want, different things, all of that can be customized. That's what 99% of people want.
Yeah. And I like to describe the living will as sort of, giving an instruction manual to the healthcare surrogate that if they do end up in that end of life situation, and you as what we would call the principal can't voice what you would want for end of life care, they have that document saying this is what they decided that they wanted or didn't want.
It also relieves a little of the emotional burden off of the surrogate to have you having already executed a document that says this is what I want. The surrogate doesn't really have to decide. Your agent doesn't really have to decide. You have already decided in advance.
So it takes off that burden. And everything that we've talked about so far is really trying to make things easier for the people you leave behind.
Correct.
Fights can happen over who's getting grandma's spoon collection, the 50-state spoon collection, something like that. But money has a way of causing family
dividing people
issues. And by setting it up and having it ready, you relieve some of that. And it relieves the burden off of the family if somebody thinks, well, they didn't do this right. Well, that's what they did. That's what they chose.
That's what Grandma wanted.
That's what Grandma wanted.
All right, Amy. So we've talked today a little bit about basic estate planning, including your last will and testament, power of attorney, healthcare surrogate designation, and living will, and a little bit about revocable living trust. So hopefully you found that informative and that gave you a little information, just a brief overview. And if you have any questions...
you can always give us a call. If you're in Kentucky and you want to set up something or you have questions for us, you can reach us at area code 502-205-9005. Or you can email us at info@berkleyoliver.com. You can get all of our info. And thanks for joining us. It was our first episode of Legally Speaking. I'm Amy.
And I'm Josh.
Thank you. Join us next time.